Hi everyone! So today I will be presenting the case of Makin versus Attorney General for New South Wales 1894 AC 57. This is an appeal case at the Supreme Court of New South Wales on 12 December 1983. The parties involved in this case are actually a husband and wife known as John Makin and Sarah Makin. John Makin and Sarah Makin were actually a baby farmers in inner Sydney. Back then, in 1890s, they had adopted a 1-month-old baby boy named Horace Amber Murray, but later on, the baby was found buried in the backyard of that couple. The issue that has arisen in this case is whether the similar fact evidence found in this case can be admitted to the court. The argument made by both parties, despite of receiving small sum of money, Mr. and Mrs. Makin allege that they are willing to adopt and care of the child from its mother because they just lost their own child. The couple claimed the death of Amber Murray was accidental. On behalf of prosecution, the prosecutions contended that the couple has killed the baby because their intention to adopt the baby was only because of money. The prosecution sought to adduce evidence from other mothers that the couple had received their children on the same basis. Moving on to the judgment by the court, the court in making their judgment has applied two limbs. First, they disallowed admissibility of previous misconduct only to show likelihood of repeating. The prosecution cannot adduce evidence from his character for the purpose of leading to the conclusion that the accused is a person likely from his criminal conduct or character to have committed the offence for which he is currently being tried, as this will rebut the presumption of innocence. Next, the court allowed admissibility of similar fact evidence if it is to show the current misconduct was designed to rebut the likelihood of it being accidental and to rebut any defense raised by the accused. The court held that the accused were rightly convicted, and this decision has been affirmed by Supreme Court. The approach by Lord Herschel in this case has led to the development of the specific purpose test. Now we move on to the analysis of the case. Basically, the general rule of similar fact evidence is inadmissible because it is prejudicial and unfair. Res inter alios acta, evidence which has nothing to do with the present charge, should be excluded. In this case, the Makins claimed that the death of the infant was an accident, but when the similar fact evidence is allowed to be admitted to the court, it has revealed the couple's wicked intention, and the death of the babies was indeed committed willfully when a similar course of conduct were done to the other victims as well. If we look into the similar fact evidence under the common law, the approach by Lord Herschel in the Makin case has led to the development of the specific purpose test. But the test has been criticized for the impossibility in compiling an exhaustive list for admitting similar fact evidence and its failure to provide any meaningful guidance on the issue. Thus, it resulted to the development of the striking similarity test and the probative value test. Now, let's look into the striking similarity test. Similar fact evidence is admissible if the repetition of the previous misconduct and the current one is strikingly similar. The rationale in the likelihood of coincidence is less when people make similar allegations, and the more strikingly similarities are, the more unlikely it becomes coincidence. In R versus Sims, the accused had been charged in an alleged homosexual offences. When the similar fact evidence adduced by the prosecution, there were about 6 counts of similar criminal offences. The court held that the similar fact evidence was admissible as those acts were strikingly similar. Next is the Boardman's probative value test. There are 2 elements under Boardman's probative value test, which are striking similarity test and also probative value outweighs prejudicial effects. In DPP versus Boardman, Boardman was actually a headmaster at a school in England for international students to learn English. He was charged and convicted of 1 count of burglary with a boy aged 16 and 1 count of inciting a boy aged 17 to commit burglary. Both complainants gave evidence that in various ways they had ended up in Boardman's study and that he had propositioned them to engage in the acts of burglary. The principles were similar fact evidence can be admitted if the judge viewed its probative force in relation to an issue in the trial as outweighing its prejudicial effect. The strength of the probative force lies in its striking similarity and where the similarity is incapable of being explained on the basis of coincidence or concoction. The court held that evidence was striking similar, that to exclude it would cause unjust. Similar fact evidence under the Malaysian law. Similar fact evidence is not specifically mentioned in the Evidence Act 1950, but we may refer to sections 14, 15, and 11 because these are the provisions that are usually invoked by judges in accepting similar fact evidence in Malaysia. Under section 14, it stated that facts showing the existence of any state of mind such as intention, knowledge, good faith, negligence, rashness, ill will or goodwill towards any particular person, or showing the existence of any state of body or bodily feeling are relevant when the existence of any such state of mind or bodily feeling in issue are relevant. Meanwhile, section 15 mentioned when there is a question whether an act was accidental or intentional or done with a particular knowledge or intention, the fact that the act formed part of series of similar occurrences in each of which the person doing the act was concerned is relevant. Lastly, section 11 mentioned that facts not otherwise relevant are relevant if they are inconsistent with any fact in issue or relevant fact. If by themselves or in connection with other facts they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. Initially, the court had been very careful in admitting similar fact evidence, which can be seen in the case of R.V. Raju and others versus R, where the learned judge has allowed similar fact evidence for the purposes of negating accident, proving identity, proving intention, and to rebut the defense against the accused. The court only allows the admission of similar fact evidence with reasonable cause. However, in recent decided cases, the common law position on similar fact evidence has been widely applied in relation to the extent of disregarding the actual position of the Evidence Act 1950. The principles from the Boardman's case has been followed in Junaidi versus BP, where the purpose of adducing similar fact evidence is justifiable on the grounds of relevancy. To rebut a defense, it is admissible provided the probative value outweighs prejudicial effect. But the Boardman's test was reformulated in DPP versus P, where in this case the accused was charged with raping two daughters. The similar fact evidence in these two counts were use of force and threat the father paid for abortion. Defense argued that there must have striking similarity before such similar fact evidence can be admitted. The court held that striking similarity is not a prerequisite for similar fact evidence to be admissible. The test is that the probative value outweighs prejudicial effect. Consequently, DPP versus P is followed by Malaysian case in Muhammad Roslan bin Desa and another, where the federal court in this case has disagreed with Boardman's requirement of striking similarity and preferred the approach in DPP versus P that similar fact evidence is admissible if the probative value outweighs prejudicial effects. As for the conclusion, the similar fact evidence in the case of Makin was eventually accepted by the court. We have to note that in cases where probative value outweighs prejudicial effect, to exclude the similar fact evidence would only cause injustice to the law. That's all from me. Thank you for watching this video. Have a nice day.